All right. If you are coming in, I am trying out live studio tonight. So I hope you can hear. If you're seeing any issues, please let me know. But we are going to get into a Fifth Circuit case tonight that left me with more questions than answers, really, I think. So we are going to be getting into this, and I will be playing this now. So let's friggin' go. Give me just 1 second. I'm hitting play.
All right, excuse me. The final case of the morning is Mendez and Covarrubias versus Bondi. Well, it's consolidated cases 25-20496 and 25, nope, sorry, one more page.
That's right here. Yes.
Yeah, 25-40701, thank you. Mr. Hayes.
Good morning, may it please the court. Benjamin Hayes for the appellants. I've reserved 4 minutes for rebuttal. This case involves a straightforward question of statutory interpretation. 8 U.S.C. section 1225A deems all aliens who are present in the United States or without being admitted or who are arriving in the United States to be applicants for admission. And then section 1225B2A requires the detention of such applicants for admission if they cannot show they are clearly and beyond a doubt entitled to be admitted.
Just a hot note, if you can hear that, please just let me know in the chat. I would really appreciate it.
The statute is clear, and this court should enforce it as written. The petitioner's argument, their contrary reading, is not only at war with the statute's text, but it would reimpose the exact same perverse regime that existed before, in which aliens who were present in the United States, contrary to the immigration laws, were given greater protections, including bond hearings, as compared to those who presented at a port of entry in compliance with law. Those individuals are subject to mandatory detention. That is what Congress was trying to eliminate. This court should not adopt that backwards result and should reverse. So I'll start with the text of section 1225, at which...
Are you aware of, I'm aware that there's a number of habeas petitions pending in this circuit and in other circuits. Do you have a rough sense of how many there are?
There were likely hundreds, if not thousands.
Well,
Yes.
your brief said 1,000, and that was filed 2 weeks ago.
Yes, that is hundreds and hundreds of them pending, at least. Yes, so there's a significant number of them, to be sure. And at this point in January, that number has increased substantially since some of the filings we submitted with other numbers as well.
Okay.
So I'll just start with the text. Start with the text of 1225, which I've mentioned, deems aliens who are present in the United States without being admitted to be applicants for admission. It deems that, it doesn't matter what they're doing, that is the category applied to them. And then B2A says they must be detained if they cannot show they're clearly and beyond a doubt entitled to be admitted. The petitioners here do not dispute that they are applicants for admission within the meaning of A1. They also do not dispute that they could not show that they are clearly and beyond a doubt entitled to be admitted. Their entire theory for why they are not subject to mandatory detention under B2A is the phrase seeking admission in section B2A. And their theory is that phrase limits the scope of, or limits the applicants of admission who are covered to those who are, in their words.
You do acknowledge that that's how it's been read historically. That's how it's been used historically.
I don't know that, so in terms of the interpretation, I actually don't know that anyone's put any interpretation on that language. But if your point is the statute has not been imposed historically to mandate detention of the full scope that it is now, that's certainly true.
What do you do with the language in Jennings versus Rodriguez, where I believe it was Justice Alito said that Section 1225 applies to aliens seeking admission into the country?
So Rob has made a point down in the comments, and I kind of want to hit on this. So the Fifth Circuit is really the only one coming in hot with this interpretation that just fuck everything we've done before. If you're here undocumented, basically overstated, whatever it may be, Like, we can just fucking detain you without bond. I don't believe any other circuit has upheld this, which is, while the Fifth Circuit is notoriously conservative, this was odd even for me to hear out of them. So that's why we're listening to this tonight, guys. I'll get back into it. Sorry.
1226 applies to detention of aliens already in the country. What do we do with that language?
Well, I think so. I think it's important to understand what Jennings was doing. Jennings was not addressing the scope of these provisions at all. Jennings was addressing a very specific question, which was whether it was reviewing a Ninth Circuit decision which applied the canon of constitutional avoidance, which had read into these statutes, 1225 and 1226, to allow for bond hearings after 6 months. They were trying to avoid a due process conclusion. And all Jennings did was say 1225 and 1226 cannot be read, fairly read, to allow for bond hearings. And that is all Jennings decided.
But you do acknowledge that that language is in the opinion.
The language is in the opinion in the sense that the court laid out a general background of a statute that it was addressing.
So is your argument that the language is dicta?
Absolutely dicta.
And aren't we bound by dicta from the United States Supreme Court?
I don't think you are bound by dicta by the Supreme Court. I think courts of appeals pay attention to persuasive dicta. I don't think this is even that. That language appears just in the background. The court is saying, here's the statutory framework that we're addressing. And so it lays out, generally speaking, what the statute does, and then it answers the questions actually presented, which has nothing whatsoever.
Isn't there another Supreme Court case where they start off with 1225A1 and then go to 12B2A and say detention is mandatory? I thought that was through a Thurgoesigian, maybe?
That could be in Thurgoesigian. It might be there. But I do think, as with Jennings, I am not aware of a Supreme Court case that has addressed this issue, right? The question of, no one disputes that Section 1222B2A mandates detention. That's not what is at issue. The question is, how many? Who? The scope of that detention authority. And there's been no Supreme Court decision that addresses that issue, which is one reason why their reliance on Nielsen versus Preup, I think, should go nowhere, because that decision, like Jennings, did not say that decision did not purport to address 1225 at all, much less its interaction with 1226. I'll turn to why their argument, the definition of seeking admission.
So Rob's absolutely correct. Again, in the comments, this is very important. A lot of the migrants are being shipped to our Dilley facility and our Fort Bliss facility here out of Texas, and they're kind of moving migrants out and into Texas. And so this is really important here, particularly when we're seeing these petitions filed.
Advocate simply cannot be right. And I think the key to why it can't be is 1225A3. And that provision says all aliens, including alien crewmen, who are applicants for admission or otherwise seeking admission or readmission to or transit through the United States shall be inspected by an immigration officer. And as we cited multiple cases in our brief, I think one from the Supreme Court, other courts of appeals, the or otherwise language operates to create a catch-all relationship between what comes before is subsumed within the broader category that comes after. And this is how we would understand spoken English. The example we gave in our brief, if your doctor tells you to bike, jog, or otherwise exercise, exercise is obviously understood as the catch-all. Bike and jogging are subparts of that. And applied to this statute here, A3, the outcome is clear.
How do we square that with 8 U.S.C. 1101 813A, which defines admission as lawful entry after inspection and authorization?
I'm not sure that changes. I'm not sure that's in conflict at all. Maybe I don't understand the point of conflict you're identifying.
I guess my question is, if on your reading of seeking an admission, it doesn't seem to square with the statute that defines it specifically as lawful entry into the United States.
After inspection and authorization by an immigration officer. Right, so I think if you are present in the United States without admission, you are deemed to be an applicant for admission. You are necessarily, by operation of law, seeking admission. Admission itself then, as defined in that provision Your Honor noted, means lawful entry after having been inspected and received authorization to be in the country by an immigration officer. So I don't see any conflict between the definition and the provisions at all.
You cannot exclude these petitioners from 1225A, right?
No.
They're clearly within 1225A, so it must mean something as to them.
Right, I think that's right, but I think
They're applicants for admission by being deemed that,
that's right, and I think the important
which
part.
means that whenever they encounter someone related to immigration, the immigration person has a duty to inspect them.
That's correct. That's right. And I think, in fact, if seeking admission, which is in both A3, but why it's relevant, it's also in B2A, right? It has to mean the same thing in both provisions. The reason why it can't mean what they say is, for one reason, it makes a complete mess out of A3, because if seeking admission means that it applies only to aliens who are going in search of, trying to acquire lawful admission to the United States, that's what their definition of what it means, then that reduces the inspection requirement to those who wish to be inspected shall be inspected.
But why doesn't your reading make a complete mess out of 1226C1? What would be the
C1.
purpose of having 1226C1 on your reading of 1225? That provision requires detention for inadmissible aliens who have committed or been charged with certain criminal acts.
I was looking at a separate subsection, 1226C1. So why have that? Well, I think a couple of things about C1. I think, first of all, I think it is clear that C1 does a lot of work beyond, even under our interpretation of 1225B2A, right? There are grounds of deportability that are listed in C1, which do not overlap at all with 1225B2A, because those individuals who are subject to deportability grounds have been admitted to the United States. So 1225, applicant for admission, that's a totally separate issue. I do think an additional reason why 1226C1 does more work, in other words, even as applied to the grounds for inadmissibility, which are listed in there under subparagraphs A and D, is because the restriction on release limits the executive's parole authority that would otherwise exist. So I think there are a couple, there's no doubt that there's a lot of work for C1 to do, even under our interpretation of 1225B2A. And I think a really important point here is, even if some portions of C1 overlap and would be redundant on our interpretation of 1225, the Supreme Court has been crystal clear, very clear. Barton versus the Barton decision, the Rimini decision, that number one, surplusage is common in legislative drafting. Courts obviously would prefer not to, in reading statute, it's a plus factor if you can read it to not have surplusage, but is absolutely not, as Rimini said, a silver bullet. And one thing Barton was very clear about, that you do not rewrite otherwise clear text to avoid redundancy in another statute.
They said that in one of the immigration cases recently, didn't they?
Barton itself was an immigration case.
Okay.
They might have said it again, but I think that just drives the point home. And that's especially true, frankly, with respect to the INA. This court in the Marquise case, I can't remember the year, and other courts have as well, noted the INA is not exactly the model of clarity, and it has been enacted, amended over time. So it is not that surprising that you're going to have redundancies that arise over time.
Didn't the Supreme Court also describe, I know they cited a case perhaps, and I get the names of the petitioners confused, cite a case that explained this background purpose of IRIRA to combine exclusion and deportation proceedings and, eliminate the difference in treatment for those who came in at the border and those who were already. Didn't the Supreme Court describe that or cite one of the cases that did?
It may have. I don't remember what case it did, but I don't think there's any controversy at all that that's exactly what IRIRA was trying to do. Prior to IRIRA, as you say, there were exclusion proceedings, which applied to those at the border presenting at a port of entry, and those individuals were subject to mandatory.
And there were a lot of differences between those disadvantaged entrance at the border from those already. It wasn't just bond, it was other things as well.
There were other things as well, and that's certainly true. I think burden of proof was one of them. But I do think that, now it's legislative history, but it's the same legislative history, the committee report that they rely on, which states that Congress's objective in enacting 1225 was to eliminate that sort of disparate favorable treatment that existed for those who had been in the country unlawfully. They got additional favorable treatment, as Your Honor mentioned, but access to bond.
I'm sorry, suddenly fucking bond is favorable treatment for a civil infraction? That's fucking wild. That is the wildest take of wildest fucking hot shit takes I've ever fucking heard. Okay, we'll get back in it.
Was one of them. And I don't think it's...
Well, the fact of the matter was that IRERA on its face did that. It made that sort of inequitable, it didn't distinguish those arriving at the port of entry and those who circumvented the port of entry. Isn't that right?
That's right.
IRERA did that. And so, everybody admits that, right?
That IRERA eliminated that disparate treatment, yes.
Yes, that it eliminated that disparate treatment. So that's not legislative history. That's statutory history.
Right, that's right. All I was indicating was that there's legislative history where Congress itself is saying that's what we want to do.
Sure.
But yes, sure, IRERA did it because
tap the
the
screen,
definition
guys.
of applicant
It's a
for
lot.
admission is incompatible with that, something like that existing, because it treats everyone who is arriving or present pre-admission puts them on the same footing.
So how does meaningful review of detention works on your reading of the statutes? Or is there no review of detention at all under 1225?
Review of detention?
Like how there are, in 1226, they do a review to determine whether or not somebody is a flight risk or whether or not they are a dangerous, a dangerousness analysis, excuse me. How does does this mean, does your reading mean that there is no meaningful review of detention?
So
Are those decisions
Good
about flight
question.
risk and danger to the community not to be considered at all?
they are not considered under 1225B2, that's correct, because as Jenny said, it doesn't allow for bond hearings. And by the way, that is also potentially true of 1226, because the bond hearings that are available under someone who is detained under 1226 are, as I understand it, a matter of regulation. Jennings says, one of the things Jennings says as to 1226 is that it can't be read to require the executive to produce bond hearings. So they exist as a matter of regulation, but both statutes, neither statute requires the provision of bond, as far as I'm aware.
Said, fuck your bond, you ain't
See, I have
doing
56
shit.
seconds. I'm not sure if there are additional questions, but
Yeah, looking at the Federal Register from 1997, both parties rely on parts of that, but at 12-323, I think, it says IRIRA extended the mandatory detention provisions to additional classes of inadmissible and deportable aliens, but provided an exception for certain witnesses. Then down a paragraph, within the same paragraph, despite being applicants for admission, aliens who are present without
These motherfuckers are wildin'. Like, let me tell you something. We went over this. The like literal monetary amount that we're paying to detain all these people is absolutely fucking wild. When almost literally more than 70% of them have committed zero crime. Zero. Not fucking one. Like, imagine paying on average about $165 per day per detainee to put all these people away. Talk about wasting your fucking tax dollars. The Fifth Circuit can eat it, man. Sorry, guys. We'll get back into it. I just had to throw that in. Oh, my bad. Sorry, wrong button.
having been admitted or paroled will be eligible for bond, but the petitioners use that eligible for bond, but it says, despite being applicants for admission.
I think it's recognizing the tension between what they are doing, and I think that's fair, but it is true too that in the same regulation that I think has been existent since the same time period around RERA, this is 8 CFR 235.3, that's the one we cite in our brief, that seems to very clearly track exactly our understanding of the statute. So at worst,
So that regulation was in effect since 1997? I pulled it up, but of course it was the most current version. So you're saying that regulation was,
Let's be so clear, okay? The practice that they are advocating for is not the practice we have followed, right? This is not what we have been doing. But now, all of a sudden, this never meant this, and this is what it means that we have to detain every single motherfucker. Like, fucking, I swear to God. I'm sorry, guys. This is making me angry.
came into effect in 97, and it provided for
I believe that's correct.
detention pending.
That is my understanding. It's a while since it's been a few
Well,
days
it's
since I
in
went
your
back.
brief, so
Right.
I hope it's accurate.
As do I. So yes, that's my understanding.
Okay, you have time for a rebuttal.
Thank you.
All right, Mr. Tan.
May it please the court, good morning, Your Honors. Michael Tan on behalf of petitioner appellees. This case is about whether Congress in 1996 said that non-citizens who enter without inspection have to be detained. And we know that Congress created in 1996 a limited detention mandate at 8 U.S.C. 1226C for aliens with crimes, as Judge Douglas referred to, and that Congress was so concerned about that rule's impact that it delayed its implementation for 2 years. But on the government's view, the same Congress also created a detention mandate that's larger by several orders of magnitude, that covers millions of people, and that somehow escaped everyone's notice for the past 30 years. That's not what Congress did in 1996 or any time since. Instead, for the
Just a side note, Law, if you need me to stop, just holler.
Yes, ma'am.
3 decades, everyone has understood 1226 to maintain the executive's discretion over whether to detain people present in the country without admission. And that follows from the text and structure of 1226, as well as the agency's contemporaneous regulations and 3 decades of consistent practice.
Well, why don't we start with 1225?
Yes,
And tell
Your
me,
Honor.
are your clients fall within the ambit of 1225, do they not?
So they are deemed applicants for admission under 1225.
Right.
They're clearly not seeking admission because they've been present in the country for years. And so the question before the court is that when Congress deemed our clients applicants for admission as a kind of legal fiction, it meant them to be treated as if they were still at the border for purposes of the detention statute. And our position is that it didn't require that. Instead, it detained them under 1226, which is the statute that applies to people apprehended inside the country. And we know that from 1226C and the Lake and Riley Act. As Judge Douglas pointed out, there's simply no way to make sense of those statutes unless you understand.
Okay, something I'm not understanding, at least when I read this, one of the guys came in 2001, the other in 2009. For all intents and purposes, they were detained within the country. I don't know why the federal government would be seeing that differently. Does that make any sense to you, Law? Because I'm not understanding that.
Yeah, I haven't listened to all of the oral arguments, but yeah, so 1225 would be, a border detention inspection. And so it sounds like what he's arguing is that they're under 1226, which is the apprehension of aliens inside the United States. I need to hear him a little bit more about how the Lake and Riley Act intersects with this, with the Section C of 1226, because that's the actual detention of criminal aliens. But again, in order to be a criminal alien, you have to have been adjudicated as such.
Okay, I got you. Thank you very much.
26 to apply to our clients in the first place. In 1996, Congress enacted the mandatory detention rule at sea and applied it to inadmissible aliens like our clients. And then even more clearly, just last year, Congress passed the Lake and Riley Act precisely to target non-citizens who have entered the country without inspection.
Let me ask you a question. 1225 says an alien present in the U.S. who has not been admitted or who arrives in the U.S. shall be deemed an applicant for admission.
That's right, Your Honor.
Doesn't your interpretation of your client's rights remove the first half of that sentence?
The first half being
alien present in the United States, because then you go further to say your clients aren't even seeking admission, which means they didn't even have to be interrogated.
So,
inspected.
With respect, Your Honor, we disagree. So we agree that Congress deemed them applicants for admission, but that was serving other purposes. And
What
I'll name
purposes does that serve?
Sure. So as Your Honors were discussing with my colleague during his argument, by deeming our clients applicants for admission, Congress changed how they'd be treated in their removal cases. It made them inadmissible. It put the burden of proof on them, and this was a sea change in IRA.
And it also denied them bond.
So we disagree because 1225b2, in our view, is limited to people who are seeking admission, not just applicants for admission. And in fact,
what does seeking admission mean in terms of 1225a?
Right. So seeking admission appears in B2, as you know, Your Honor, and we agree with Judge Douglas that it should be given its plain meaning, seeking a lawful entry into the country. And our view is people who are already present here aren't engaged.
Case, let me go back. In that case, all 1225a should have said was an alien who arrives in the United States shall be deemed an applicant for admission.
Well, again, we disagree, Your Honor, because the deeming of our clients as present without admission still does work insofar as changing their status in their removal proceedings.
Not in 1220, but you're saying they're excluded from 1225b2.
Because of the language specifying that you need to be seeking admission, and we think as a matter of plain reading, people who are already in the country, in our clients' cases for many years, simply aren't seeking admission. This is also consistent, Your Honor,
What are they seeking? They're seeking cancellation of removal.
Right, and that's, I'm sorry, Your Honor, if I may, thank you. So they're seeking relief, and that's another reason why the government's reading is quite strained here. And this is clear by the Supreme Court's recent decision in Sanchez against Mayorkas, which makes clear that people like our clients, when they seek relief, they're seeking a lawful status here through cancellation, in that case, temporary protected status, asylum, but that doesn't constitute an admission. It doesn't go backwards in time and cure the fact of them having made an unlawful entry. It just protects them from removal and gives them a lawful status in the country. So in our view, our clients are seeking relief, seeking lawful status, but they aren't seeking admission, and that's what the Supreme Court said in Sanchez. That's precisely why the clients there couldn't apply for green cards, because they were still unlawful. They were still unlawful entrants.
I think you were about to answer a question that I have, and that was about the Lake and Riley Act.
Yes.
So if everyone is supposed to be detained under 1225, then what is the argument as to what the need for both 1226C1 and the Lake and Riley Act?
Yes, so we agree, Your Honor, that if the government were right and that our clients, people like our clients, were under 1225B, that would effectively gut the Lake and Riley Act, because the Lake and Riley Act is aimed at people who entered without inspection and committed certain crimes. Now, the government says no. Lake and Riley is still serving to eliminate their release on parole. But that's a misreading of how the statute is structured and is inconsistent with Justice Alito's opinion in Nielsen against Priap, where the court explained that the only people subject to mandatory detention under 1226C, which is what the Lake and Riley Act amended, are the people who were arrested under 1226A in the first place. The Ninth Circuit had held otherwise. They treated 1226C as providing its own arrest authority and then read that statute to only apply to people who the government picked up right away when they were released from criminal custody. The Supreme Court, Justice Alito, rejected the entire premise of that interpretation and said, no, A and C work together. You're only subject to 1226C if you are arrested under 1226A in the first place. That is right in the middle, that is clear from the text of PREAP. And so if the government is right that 1225 is the applicable statute, 1226C, and I know there's a lot of statutory provisions here, but that statute never comes into the picture, and those clients become eligible for parole.
They're redundant. They're redundant. Why are they not just redundant?
Well, they are.
These are not superfluity arguments. They're redundancy arguments.
Right. So you're asking, do the statutes overlap? In our view, they don't.
Well, they
we've
do.
Taken.
They may overlap. I mean, obviously, you're saying your clients overlap because you're saying your clients are aliens present in the United States under 1225A, but they're also eligible for bond under 1226. So there's potential for overlap.
So yes, we agree that both 1225 and 1226 address their circumstances, but we don't think there's an overlap between the detention statutes, again, because we think 1225B2 only applies to those who are seeking admission, and that 1226 is the applicable statute for people arrested in the interior, and that's consistent with PREAP. I think the other reason why it would be very difficult to read the statutes to overlap, Judge Jones, is that 1225B2 is a mandatory detention statute. It requires the government to take people into custody. 1226A is discretionary, and so it wouldn't make sense to have the two work together because that would effectively...
1226 also applies to a vast number of aliens who were admitted legally,
Yes.
But then overstayed their visas.
That's right.
And it also applies to a vast number who are, admitted erroneously.
Absolutely, Your Honor.
So that means it's much broader than 1226B. Because Judge Jones just asked you if the C1 in 1226 applies both to aliens who were inadmissible and also were admitted and then committed crimes and became deportable. That is if we have a Venn diagram, that is a larger circle than the 1226B seeking admission, applicants for admission, isn't it? So they may overlap, but only in part.
I mean, so just if I may pause for a second. So I think the government is arguing that 1225 is the applicable statute for everyone who's inadmissible, and that 1226 applies to people who have been admitted here and are subject to deportability. And our position is that that does not make. Both. Oh, I'm sorry.
It says both. The government says both. There's C1A and D says is inadmissible, but C1B, C, E say, B and C say is deportable. Isn't that addressing a different kind of person? Someone who's admitted, commits a crime, and is thereby deportable because of committing a crime.
So we agree that 1226C applies to both inadmissible and deportable aliens, and we think that favors our position because C is written as an exception to 1226A. That's in the plain language of the statute. And so the only way to read C is to understand that 1226A applies to inadmissible aliens in the first place.
I guess, can you explain to me, just as a general matter of common sense,
Sure.
Someone who is, you say seeking admission means they've presented themselves to at a port of entry, so they're seeking admission. And 1226B says, well, if you're doing that, you can't get a bond hearing, right? Can't get a bond hearing. This other group of people who have not presented themselves at a port of entry, but who are, picked up and they're being deported, they're being removed, they do have the ability to get a bond hearing. Why make that distinction?
Sure. So if I may reframe and answer the question, Your Honor. So it's not simply about whether you get a bond hearing, but whether the agency has to detain you or whether it has discretion over the decision to detain.
Okay, put it that way then. Why would you have
Right.
to detain that first group of people?
Right, and
but
so-
not the other second?
The legislative history is largely silent on this issue. Our best understanding of why Congress wanted to avoid creating the detention mandate that the government is advancing here is that it would have overwhelmed the system. There were literally 2 million people who would have been subject to this detention rule had it actually gone into effect in 1996. And we know from the way Congress behaved when it enacted 1226C, the detention mandate it actually enacted, it took pains to defer implementation of that much smaller detention mandate
because they were concerned about the
because it was
number of people who might fall under that.
exactly that is our understanding of the legislative record, Your Honor.
What do you say about this CFR 8235.2B, I think it is,
So
which provides for detention under 1225B. It's very express.
that's right.
Has that been in effect since 1997?
That's right, Your Honor. It has been in effect in 1997. I believe you're referring to the regulation
Yes.
For
where
asylum
an
seekers.
alien is considered for expedited removal or
Yes.
fast-track.
I'm sorry, Law, what did you say, hon?
So the 1225B covers asylum. So they're talking about the detention for asylum seekers.
Yeah, like I was kind of not understanding. Was he just making the argument basically that, yeah, I guess you could detain them based on this language, but don't because it'll overwhelm this is I'm really confused by where he's going with this.
So he's arguing. So there's two things in conflict here. One is there's clear authority to detain without bond for people who are seeking admission at the border. And then the other part of this is the people who are already present here, there's not clear authority to detain without bond. So then they're asking him, well, why would Congress make the distinction there? And so his answer was there that it's just not practical to detain everybody without bond because it would overwhelm the system. So Congress made a distinction that if they're trying to enter, it's a way to kind of stem the tide that you can detain them without bond there, but that Congress didn't draw that hard line and that it's a discretionary function when it happens within for people who are already present. So whether they overstayed a visa or whatever the case may be, that there's a distinction there that they aren't necessarily ordered to be held without bond. And that's the way that that for 30 years
Yeah.
until this administration, DHS operated, is that you can, place them into removal proceedings, but they're entitled to a bond. And the reason for that is that we just simply couldn't house everybody. So he's making the distinction that it can't be treated the same because Congress designed it to be different.
Ah, gotcha. Okay, sorry. I got lost there. So thank you for clarifying that. I appreciate it. We'll get back into it. Got about 15 minutes left.
Process, they're found to not be eligible, and then the reg says they'll be detained under B2. I have two responses to that, Your Honor. At the same time, the agency enacted a series of other regulations, which are cited in our brief, affording discretionary release on bond to non-citizens who are arrested in the interior. And the consistent practice over 30 years has been to follow those regulations. So we think that is much more probative of how the statute should be interpreted. Under Loper-Bright, those two facts, contemporaneous regulations and consistent practice, are given great weight, or traditionally have been given great weight.
Well, I mean, the Supreme Court didn't think very much of that argument in the Pereira case.
As to the
Pereira had to do with notices to appeal, which had been erroneously incomplete for at least 10 years, and the court said they don't follow the law.
That's true, Your Honor. I think here the consistent practice is still worthy of significant consideration.
Pardon me.
No.
Yeah, it seems to me equally plausible interpretation of the regulatory landscape, that yes, Congress was ambivalent about actually requiring everybody to be detained, but at the same time, it realized what the law said, which is the preface to that view of the Federal Register, combined with the fact that the Federal Register said, well, you know, a lot of people realize that when we've allowed people to go free pending removal proceedings, that they abscond and they never show up. So there's been a tension on both sides of that for the entirety since IRIRA was passed, well, hasn't there?
So we agree that regulation is included in the 1997 rule, along with the regulations affording release on bond.
What I'm
and then
saying,
those were
there's
put
a
into
tension.
practice.
Right.
So we agree that we think that first
And
regulation.
if the law said what the law says, and if it's interpreted to require inspection statements consistent with inspection of all aliens present in the U.S. who are deemed applicants for admission, then that just is part of the underlying law that a president can exercise discretion and enforce.
Right. So our bottom line position on that regulation, Your Honor, is that it's just contrary to the statute. And again, I would go back to the Lake and Riley Act in particular. And like, I will admit there's something a little surreal about having worked on these cases, because just last year, we know Congress passed the most significant immigration legislation that we've seen in decades, precisely to, I'm sorry, Your Honor.
Go ahead, excuse me.
Precisely to take aim at non-citizens who are present without admission and have certain crimes. And so effectively, the government has to be arguing that Congress just doesn't understand its own statute.
Well, quite the contrary, because when Lake and Riley was passed, the 30-year procedure of allowing bond to criminal aliens was still in existence, right?
Right.
Lake and Riley was done to reinforce the unavailability of bond at a time when the statutory, before the administration had read the law differently.
So with respect, Your Honor, if Congress thought the agency had got it wrong for 30 years, it could have corrected that problem. But also, I think that the 30-year backdrop supports our position insofar as Congress legislated with that backdrop in mind. And so under cases like Brown and Williamson Tobacco Company, you can understand Lake and Riley if you want to take that approach as ratifying the longstanding agency practice at the time, which is that certain people were bond eligible, and that's why Congress had to deal with that problem. I don't think you need to go there. I think Congress was working against an understanding that had been in place for 30 years, that certain people are eligible for bond. We're not happy with that anymore, particularly those we're unhappy about the folks with certain criminal records, so we're gonna have to take steps to eliminate the option of release. It'd be very strange for Congress to have done that if all along people were detained under 1225, subject to that mandatory detention rule, subject to possible release on parole, which of course Lake and Riley doesn't even address in its own terms.
What do you know about the Lemus decision that was issued around 2012?
Give me a second here, Cass.
By the INA.
Yes,
by the BIA.
That's right, Your Honor. So Lemus involves certain grounds of inadmissibility that apply to people who have been unlawfully present here. It doesn't.
I'm so sorry. I'm using TikTok Studio and it's a kind of a pain in the butt. I've never used it before, but please go ahead, Law.
Yeah, so I think this point is pretty interesting here. So what he's saying is that the Lake and Riley Act created a mandatory detention under 1226C for certain criminal offenses committed by non-citizens. So what he's basically saying here, and I think it's a really solid point, is that if the administration, if the executive already had the authority under 1225B2 to mandatorily detain everybody, then why would Congress need to expand it in 1226C for these particular crimes under the Lake and Riley Act? So the fact that the act was passed kind of undercuts this premise that mandatory detention has always been the law. It's just that for 30 years we didn't follow it. Instead of it bolsters that point by saying that, well, hey, if they always had this authority under B2, 1225 B2, then why did Congress need to, create an additional layer of authority in 1226C? So I think it's a pretty solid argument.
Yeah, no. And when you go into the dissenting opinion on this, one of the best things she said was like, I feel like Congress would have been more explicit, if this wasn't their like intent, right? Like she talked about that and she was like, arguably now with this ruling, the court just thinks that the border is everywhere. Like they're not following any sort of pretext that we've known or understood, for your point, like the past 30 years now. So yeah, like I did find that to be an interesting point as well. Thank you.
Yeah, well, and you know me, I'm always if you don't like the law, change the law. Don't try to reinterpret it.
Well, I mean, yeah, and that's probably one of the best points he's made so far, is that if they already had this ability, why weren't they doing it? That doesn't really make a lot of sense. So yeah, I like that. Okay, we got 10 or so minutes left.
It doesn't address the detention statutes at issue here. I think to the extent the board assumed that deeming someone an applicant for admission means they're seeking admission for every purpose, we disagree with the board. And in fact, if you look at the underlying statute, again, we think if anything, it supports our position. That's 1182A9, where Congress reflected a recognition, differentiated between people who seek admission and people who enter unlawfully. So it applied a 10-year bar to people who seek admission, but a lifetime bar, permanent bar on people who enter the country unlawfully after being present here for, I believe, more than a year.
Well, I didn't mean the substance of lemus, but I believe it either refers to the extraordinarily broad interpretation or definition in 1225A1. I still don't understand what is the point of the definition in 1225A1, which talks about aliens who have not been admitted or who arrived, all being subject to inspection.
Right, so
You don't deny that your clients are subject to inspection.
we absolutely, Your Honor. And I think, again, we see the purpose of the deeming provision is completely changing how removal cases work.
Well, then what do you do?
People who, I'm sorry, Your Honor.
I'm sorry, then what do you do with 1225A5, which says an applicant for admission may be required to state under oath any information sought by an immigration officer regarding the purposes and intentions of the applicant in seeking admission to the United States?
So we would also argue that provision applies to people who are actually seeking to enter the United States, to make a lawful entry to the United States.
So basically you have a definition in 1225A1 and nothing in the rest of the provision pertains to those people.
Well, there's also the inspection provision that the government relies on at A3, and I see I have 10 seconds, so I'd like to finish my answer here, if that's with the permission of the court. Thank you. So the government argues that applicants for admission are a subset of people seeking admission, and that's made clear by the inspection provision at A3. The point I want to make is that it's actually the opposite, and that the statute actually favors our position. Applicants for admission is a larger set of aliens than those seeking admission because it includes people who are both seeking admission and those who aren't, people who are present here without admission. And in fact, if the government were right, it would render the statute surplusage, because if it's true that applicants for admission are a subset of seeking admission, there's no need for Congress to have specified applicants for admission in that statute. There have to be some applicants for admission who aren't seeking admission in order to avoid the surplusage problem. But that is an instance in which deeming does the work of subjecting our clients to inspection insofar as they are applicants for admission. The statute requires the inspection of all applicants for admission, seeking admission or not, as well as any other alien who's seeking admission, readmission, or transit through the United States.
Well, I mean, the sentence statement says can be testify under oath regarding the purposes and intentions of the applicant in seeking admission.
Yes.
In other words, it pretty much uses applicant as one identical to one seeking admission in A5, as far as I think.
Well, we disagree. We think the statute is contemplating people, an applicant who's actually seeking admission, and again, someone who's apprehended in the interior, seeking relief in a removal proceeding. They are not seeking admission. They wouldn't be subject to that particular provision. So with that, we would urge the court to affirm the decisions below. Thank you very much, Your Honor.
Okay, thank you. Mr. Hayes.
Just a few points in rebuttal, Your Honor. So I want to say briefly something about the Lincoln Riley Act, because that got some attention. I think, Judge Jones, I believe you are exactly right in understanding the point that the long practice, which my friends rely on so much in terms of what the executive was doing, is actually really helpful for purposes of understanding why the Lincoln Riley Act, why Congress did what it did. Yes, Congress was well aware that the executive was not enforcing the law, and I think there's no way to understand the Lincoln Riley Act, of all things, as being an endorsement or codification of Congress's action. That was a very firm statement by Congress. They were very upset at the manner in which the executive was carrying out detention authority, and they were meaning to strictly confine it. So I don't think that can possibly be understood as a ratification of prior practice. And it was focused on a particular issue. So obviously they could have overhauled the immigration system again, but they were trying to address something specific. On to another point. I have yet to hear from my friend on the other side how his definition of seeking admission could possibly work within the context of this statute. Again, their definition is that the alien has to be voluntarily seeking some affirmative act, seeking out, trying to acquire the thing. So imagine, how would one know if an alien is moving between ports of entry? How on earth is one to know whether they are seeking admission or not? I have no idea. Do you just take their word for it? Maybe they don't confront an immigration officer at all. And at that point is the question how long they've been in the United States or how far they've gotten into the United States. They make a big deal out of the fact that they've been here a while. But the key point is the statute doesn't say anything about those issues. And the reason it doesn't say anything about those issues is because that is not what the statute was intended to address. And Congress knows how to write in temporal or geographic limitations in statutes when it wants to. It did that in the expedited removal provision in 1225B1.
You talked earlier about all of the habeas cases that have come to pass since in the last couple of months. And your friend on the other side talked about the 2-year delay that was given with the changes that were made. There was no such delay given here on this new reading of 1225. Is that correct, or am I?
I mean, back in you are correct in that ARERA did not include a transition period.
Why do you think that is?
I'm not sure the answer. It could well have been, number one, that the language of 1226 is crystal clear, right? That they must take into custody aliens who are the criminal aliens. And so because that language is so unbelievably clear, Congress could have thought that the executive would take that more seriously. I'm not sure. It also could be that the detention facilities needed to house criminal aliens are different than might otherwise be with respect to aliens who haven't committed, a felony or a crime in the United States. I don't know that the legislative history says anything about that, but I think that's a very not a sound ground on which to otherwise overrule clear statutory text on this issue.
That is straight fucking nonsense, that detention facilities need to be different to house criminal aliens versus non-criminal aliens. I don't know. I've seen a lot of detention facilities. They're never usually fucking different. Maybe I'm just being crazy here, but could just be.
There are some non-criminal detention centers that are more like camps where you have some freedom of movement, but there's still a barbed wire fence. You're not free to leave.
That's kind of what I was saying. Like usually if they're like, I would think that if they're being criminally held on like charges in the US, that's not an immigrant detention facility at that point. That's just like straight up jail, right?
Yeah, but I mean, these are, so if you are being held for like a crime of deportability and you're being kicked out of the country because of that, then you are a criminal detainee at that point, getting kicked out of the country. So they treat those differently than somebody who's like an asylum seeker who's being detained pending their hearing.
Interesting. Okay, I didn't think about it that way, but that makes sense. Thank you.
In just the remaining seconds I have, I just want to thank the court for having been willing to expedite the case, both in brief and in oral argument. The one thing I'll say beyond that is I've alluded to earlier about the significant uptick in these habeas cases that has been a large burden for a while, but just in the month of January, it
You're
has, I've been
welcome.
told by the U.S. Attorney's Office, exponentially larger. So
Is this issue pending in front of any other circuits?
it is pending in front of almost all other circuits, the six, some of them on expedited schedules as well.
Have they had any oral arguments in any of those cases?
There is an oral argument in 7th today, and there are others scheduled in March, 2 scheduled in March, and I may be forgetting one.
The panel in the Seventh Circuit is not constrained by the temporary injunction case that they had something with a C, right?
I mean, that is the Castanon-Neva,
Yes,
I believe is one.
Castagnon, yeah.
The 1225 issue is a portion of that, and the motions panel reached it. So, I mean, I can't speak for what the Seventh Circuit will do, but it is a live issue in that case. And that
Well, in our court, we would not be bound by a motions panel, that's all I'm saying.
Oh, no, I agree with that. I agree with
Okay.
that. So it is for the merits panel to decide. But I'll just finish up by saying, given that, I know it's not the court's practice, certainly, or preference to resolve a case in this way, but if the court would be willing, I think this would be the circumstance where it would be appropriate to resolve the case by order with disposition noted and opinion to follow. We filed a motion to this effect. It's pending with the court, but I just wanted to make sure that was for your consideration. And I thank the court for its time.
Well, let me just pursue one other thing about that. The petitioners responded to that and said that that would really make things more difficult for everybody concerned. What about that?
I'm not sure how it would. We have one issue before the court now, the statutory question. And if the disposition was, as we hope it would be, reversal, then that, I don't know how that could be misconstrued as anything other than reversal on the statutory question. There's not, in other words, a due process claim here or otherwise. So I don't know I don't know how that would make things more difficult for anybody. And of course, once the decision issues, then the reasoning of the court will be plain.
Suppose we affirmed, would that make it more difficult?
I don't think it would. You'd be just endorsing the statutory interpretation.
Okay.
All
the
right,
court.
thank you. We're in recess.
Okay, thoughts, Law? I mean, we already know
Oh,
what they did, but
what a journey of statutory interpretation, which is always fun. And when you've got a 76-year-old who doesn't seem to appreciate the distinctions, the writing's kind of on the wall. The three-judge panel, Jones is a 76-year-old Reagan appointee.
is that
She was
old
the old
lady?
lady asking. Yep,
Okay,
yeah. Duncan was on here. He's a Trump appointee, so he
shocker.
kept quiet and just co-signed on everything. And then Douglas was the one asking, the government the tougher questions. And with that zinger at the end, she's a Biden appointee. So, um,
Her dissent
yeah, the writing was kind of on the wall with that panel.
fierce. Like, I mean, it was longer, obviously, than the actual opinion itself, and it was rough. Like, she just let him have it and did not give any fucks. I mean, I'm here for that. Like, it did not bother me at all. I don't know if anything's come out of the Seventh Circuit yet. I'd have to look. I don't know if there's anything existing on this, but to me, I think you're right. The strongest point, Layden, like, well, if they already had this power all along, why did they need the Lake and Riley Act to do what they did? And I just cannot for the life of me fathom how they came to this conclusion when it's not in keeping with anything that we've done for the past 30 years. But I think letting it go, that it was kind of like executive purview, was the nail in the coffin. Because if they have the choice to do it and they do it, then I guess they can't really stop them from doing it. So Congress will need to, I guess, set that right at some point. But yeah, it's a real problem.
Oh yeah, and I think, it always troubles me when a statute has two distinct terms, and then, for years we've treated them as distinct terms, and then somebody else comes up and says, those aren't distinct terms. We're going to treat as seeking admission, that somebody's actually seeking for admission currently as the same thing as an applicant for admission, when they're used differently, but then somebody comes along and decides, you know what, we're just going to treat those things as if they're the same.
Yeah. Uh, Ramblings of feelings as everyone tries to be. Oh my God, Smokey, come here, Pookie Bear. You got a lot to say in the comments. Get up here. Sorry, I'm getting agitated now. Um, yeah, I don't really honestly, this ruling made zero sense to me. I don't think the Seventh Circuit is going to have quite the same interpretation of this. If it's just my guess, I'd have to look and see if they did, but
I'm looking at it now, and they rejected the government's broad claim that 1225b2 applies to all unlawfully present in the interior. So,
oh.
yeah, they essentially came to the opposite opinion of the Fifth Circuit. So now we have a circuit split, which means knock, knock, knocking on SCOTUS's door.
Oh yeah, they will. And it won't even be a severe circuit split. I think maybe like two circuits or one or two will go with what the fifth said, and all the other circuits will be like, nah, fuck this, and it'll still get to SCOTUS somehow. Um, I mean, but like somebody pointed this out earlier, and it's almost kind of makes sense. Like at this point, they're gonna kind of have to, because Texas, is a huge place where a lot of these migrants are being sent. And it is now pouring rain outside. So if my internet dies, please know I didn't just hang up on y'all. It was accidental. But yeah, I don't think that they're gonna have much of a choice other than to kind of get it straightened out. At least if that's my opinion.
And I can tell you from firsthand experience that the Minnesota District Court is treating this as people who are here that are not, seeking entry at a port of entry are being treated as if they're entitled to bond. So we've uh, the I don't know if the government has appealed any of those yet. Don't think there's any attorneys left to actually file the appeal back at the office, at the attorney's office anymore, because all of them have quit. But at least in Minnesota, they've treated as everybody who is covered under 1225B is entitled to a bond.
I mean, it makes sense. All right, guys. My kids just woke up from the hailing outside, so I'm gonna have to cut this abruptly short. And I really apologize, Law. Thank you so much for being here.
No problem.
But
Go be super mom.
I gotta go take care of these kiddos. I'll talk to you guys later. Love y'all. Bye.